Okay, good morning, everyone. I am going to mute everybody. If you have a question that you want to ask, feel free to unmute yourself and ask the question. So I'm going to start out with a couple changes to our law that took place July 1st. I also want to thank all the people that came to the live session that we had here last week. We had 30 people in attendance to hear the changes to the statute and to the contract forms, and we decided we'll repeat that again for people that want to attend live, and we'll get you the dates here near future. The two laws that I want to make sure that everybody are familiar with that changed before I discuss these other items that I want to cover today. The resale certificates, POA and condo. From the POA and condo, the ordering of the documents, and they've renamed it to be called a resale certificate. So we still have our law in Virginia for POA and condo. That has not changed. What they have done is they have pulled out of those two laws the resale certificate and made it a separate law. So here's what they have done with the statute. The new packet, which would have to be delivered for any transaction that is ratified after June 30th at midnight. So July 1 forward, you would need to have the new packet ordered and delivered. The new packet has 30 items in it, 30 items. So you can see them here in the statute. There are 30 items now to a complete package. I'm not going to go over each one of those. You can read through them, but I would suggest that you go to DPOR, your licensing authority, and I would go to POA condo disclosures, and there's the new form for for acknowledging the POA and condo certificate order. Plus, they have the new form that all POA and condos must use now as the cover sheet. And that cover sheet is like where do I find this in this law or in this disclosure? So it will be they list each one as an appendix, appendices. Appendix 1, Appendix 2, Appendix 3, and each one of those correspond to 1, 2, 3, 4, 5. You get the idea there. So it's like a table of contents. If you're looking for a particular thing in the act or in the disclosure now, it will be easy to locate. Now, they also clarified that a day is a calendar day. We had some people, I don't know where they got that misconception that it was a business day. So if the documents are delivered today, this is the first day and it ends tomorrow at midnight. Okay. Also, now when your seller orders the documents, the money is due up front, no longer at settlement. Okay. So those are the basic changes to this statute. If you had already ordered the documents before July 1st and your contract was ratified before July 1st, fine, you can use those documents. But if the seller ordered the documents, had them in hand, and they were prior to July 1st, and now they ratify a contract after July 1st, they're going to have to order the new documents. Okay. Everyone okay with that? And I went over this in greater detail in a previous session, and we go over it in great detail in our live sessions. Okay. So the second one that changed July 1st that I really want you to be familiar with is settlement fees in the state of Virginia. Okay, settlement fees. We've been preaching for quite a while that you cannot have what we call split settlements. There can only be one settlement agent in the state of Virginia. Okay, and our contract and our law says the buyer has the absolute right to choose who that will be, and it cannot be waived or changed or varied by written agreement. Now, what did change is that when everybody got that letter from Virginia that said no split settlements, then we had some title companies decide that, hey, we can charge whatever we want because everybody has to use us. So here's the new law. If the seller, okay, if the seller hires an attorney, not a title company, so it wouldn't be RTS Title representing the seller, it would be here at our office, Louisa Miranda White, attorney, okay? But you have to understand, they are serving in the capacity of an attorney, not representing RTS Title. So if the seller says that they're going to use an attorney, then the settlement agent may not collect any fees from a represented seller payable to the settlement agent, its subsidiaries, affiliates, or subcontractors without first obtaining the written consent of the seller's counsel. So as a buyer's agent, as a listing agent, I'm going to go over this with the seller, right? And I'm going to say, you always have the right to be represented by an attorney in your transaction. We can always add a clause to your contract that you reserve the right to be represented by legal counsel. But I think it would suffice if we just send a notice over saying that, hey, the seller will be represented in this transaction by an attorney. Okay, so that's a big change.
Could you talk about the fee? What happened? They have to pay the lawyer and also have to pay the settlement attorney?
No, they would not be able to. The settlement attorney cannot charge any fees to the seller if the seller has hired an attorney without that seller's counsel's permission. So if there is going to be a fee charged for a service and it's a legal fee, then the seller's counsel is probably not going to complain. But if you're going to try to overcharge for the services that they provide during this transaction, then the seller's counsel says, no, they can't charge you. Now, what you have to make sure, I think the seller understands, is that they're going to probably be paying a pretty good size hourly fee to their counsel to represent them. So if they don't really need that counsel, then I would consider whether or not I wanted to pay that much money to have somebody review my documents. But, if you think it's going to be a contentious transaction, then, they may want to have their attorney. But the main reason they put this in is to make sure that the other side knows, hey, I've got counsel, don't try to slip any ridiculous fees. So it doesn't mean there won't be any fees paid to the title company that's doing the settlement, because they may be handling the payoffs and stuff like that. It just means that, hey, I've got somebody looking over the shoulder, so hey, and I'm being represented by them. So don't try to do anything out of the ordinary. Okay. Good. So those are the two that I wanted to go over and just revisit today, and we'll do another session or two live where we have everybody that wants to attend can ask questions. Okay. Now, I have a couple of things that I want to discuss also that came up. Let me bring up. It's not sales contract for a second. Okay, so one before I address this, if you get a call from someone who says, look, my neighbor wants to buy my property, I'm a FSBO, can you write this contract for us and how much will you charge us? You have to say, no, I cannot write that contract for you. I can do a contract as part of a transaction, but I can't be paid just to write a contract. That requires an attorney in the state of Virginia. That is against our statute. Okay. So when they want you to represent the buyer, okay, want you to represent them, then you need to either do a limited service agreement or an independent contractor agreement stating that you will be representing them. This is what you will do in the transaction, and it's not just write the contract, okay? And this is how much we want to be paid. So if there's a for sale by owner and you're going to represent the buyer with this agreement, then you need to get the seller to sign an unrepresented party form so they know what they are getting into, okay? But you can't just help someone. And for heaven's sakes, don't help someone outside of the company, okay? To do them a favor. You're risking your license, all right? So it's always got to be run through the company, okay? And even if you're FSBOing your own property, I don't understand why you would do that and not run it through the company, but make sure the proper disclosures are filled out and signed. And, you know, our statute says you have to keep the company involved in any transaction which you are a party to. So can't help people outside of the firm. And NVAR forms are copyrighted. You cannot use NVAR forms to give to members of the public.
So the only thing we have to do,
Somebody,
Larry, if we have a buyer, if something happened like that, we don't have to make a listing. The only thing it is, we just send them a contract from the buyer, right?
no,
No?
you have to be, if you're representing the buyer, then you don't need a listing from the seller. But if you're
Okay.
representing a buyer, you've got to have it in writing. So if you're going to go outside and take your buyer client, show them an unlisted property, you need a right to show letter to take the people on the property to protect yourself in case something happens to the client while they're on the property. You need to request the compensation at first contact, not first contract, according to our code of ethics, okay? And unrepresented party form. Okay? If it's a property that's not listed.
So these two have to be signed by the seller.
Yes, those have to be signed by the seller.
Thank you.
Okay, you need to protect yourself, and everything has to be in writing. And I'm going to share with you a case from DPOR here in a few minutes about making sure everything is in writing. Okay. Any questions about that? If you have a question, unmute yourself and you can ask it. Okay. I want to talk about paragraph 3 for a second. Buyer's deposit. Okay. And then the amount of whatever goes in, you write it in this blank. Okay. Check or bank wired funds and or by a note, if it's going to be a note, we've discussed this before, will be held by the following escrow agent. The reason that they took out the blank where you could write who's holding the deposit, the settlement agent, because under the settlement agent paragraph, okay, RESA, remember the buyer has the right to choose who that title company will be, and it can't be waived or varied by agreement. So now the state of Virginia, I mean, in our contract, they have highlighted the whole part of RESA as far as who has the right to choose, what that person can do, variation by agreement. So we can't, so what is a contract? It is an agreement. So even though in this paragraph, the buyer designates ABC to be their title company, they still have 10 days to contact the title company, okay? And they can change their mind in that 10-day period. But what would be required then is for you to send a notice over to the other side that they have made this change, okay? And they have every right to do that. Okay, now I don't recommend that you do that, you know, because once everything gets started, you don't want to be switching up. But technically, they could do it. But this deposit, okay, this deposit, okay, must be delivered to the settlement agent. Okay, so the buyer checks they have delivered the deposit to the escrow agent. If this is Fairfax Realty Select, because at Fairfax Realty of Tyson's, we do not accept checks made out to us, okay? Has to be made out to a title company. But if it's a settlement agent, okay, or co-op broker, so if the check's made out to Fairfax Realty Select, okay, then how many days does the broker have to get the earnest money deposit check into the bank? Well, everyone knows it's 5 business banking days unless everybody agreed to some other time frame. But if it's to be held by anybody else other than your company, then the check has not been delivered if it is handed to the agent. If it's a settlement agent and that check's handed to you, that check has not been delivered to the settlement agent, okay? So you have to check, will deliver the deposit to the escrow agent by X number of days after date of ratification. Now, it is incumbent upon you to make sure that if the buyer is going to deliver this check to the escrow agent, that it is delivered by 9 p.m. on the day specified. Okay? It's imperative that you do that. Now, I want to bring up a change to our law that took place in 2022, I believe it was. Let me find it here. Here it is. Protection of escrow funds. Now, it clarifies that upon the ratification of a contract, okay, an earnest money deposit received by the principal broker or supervising broker or an agent of such principal or supervising broker that will be held in the firm's escrow account shall be placed in such account by the end of the 5th business banking day following ratification, unless otherwise agreed to in writing by the principals to the transaction. So this is already a depot rule, but now under Senate Bill 533, it's statute. Okay. So one example would be in the state of Virginia, in a regular transaction, when the seller signs the last change to the contract, and we have 2 documents, or the buyer signs the last change, and we have 2 documents that mirror each other, we have ratification of the contract. Okay. So that check needs to be in the bank within 5 business banking days after ratification, unless the parties agreed otherwise. So our contract actually says ratification is when it is ratified and delivered. Okay, so they've agreed to the adjustment that the 5 days would start after it's delivered. Right. However, what about a short sale? When is a short sale contract ratified? Now, I hear this all the time in classes when I ask this, when the bank approves the contract. That is not so. In a short sale, the seller still owns the property. The buyer is still buying the property. When they have ratified a contract, that check needs to be in the bank within 5 business banking days, because approval by the bank is nothing but a contingency, just like a contingency for financing or home inspection. So unless there has been an addendum to the contract changing the date, you buyer agents better make sure the check is in the bank within 5 business banking days. Now, this is where our statute gets interesting. If an earnest money deposit, okay, will not be held in the firm's escrow account, the principal broker or supervising broker shall ensure that the earnest money deposit is delivered to the escrow agent named in the contract by the end of the 5th business banking day following receipt of the deposit, unless otherwise agreed to in writing. So now our statute says, look, agent, if you have received a check made out to RTS Title Company, okay, then you have to make sure that check is delivered within 5 business banking days to RTS Title. Okay. If they have checked the box, they will deliver it themselves. You have to stay on top of this. If it says the buyer will deliver the deposit to RTS Title, you better have good written communications where you remind them that they have to deliver this by this time. Now, our state statute says if any condition to the contract changes, you must inform the other side in writing. So you're the buyer's agent. 9 p.m. on that day that they were supposed to deliver that earnest money to the title company, and it has not been done. You have to inform the other side in writing that they have not made this deposit, and detail that you have followed up to try to make sure it was done. I had someone in my class at the association on Saturday that shared that she had to pay a fine because she believed her client when they said they delivered the check, and she didn't ensure that it had, and they never had delivered the check. So when you make sure that check is delivered, you want something in writing from the title company that they have received it. So this is a little change from what we're used to. DPOR still has the rule, but now there is a state statute that also says you must do this. Okay? Any questions about that? Okay, I want to share with you a case from DPOR. And it's not disclosing your relationship in writing to a seller or a buyer. Now, the MLS listing instructed agents to contact the seller or owner directly regarding showings, inquiries, offers, and everything else until closing. And what happened is this agent listed a property that her husband owned, right? Now, there was an exclusive right to represent buyer agreement signed with another company, but there was still never any disclosure, okay? And well, actually it was signed with the same company and the same agent. So she submitted a purchase agreement, but never anywhere did they disclose in writing, even though she was negotiating for this party, that she was related to the seller. Now, this ended up with her having to pay a $500 fine and take 6 classroom hours of education. Now, this case was before our statute change. Now they've changed our statute. Real property, duty to disclose ownership interest, provides that if a real estate licensee knows or should have known that he, anyone in his family, firm, or entity in which he has an ownership interest is attempting to acquire, sell, or lease a property, and the licensee is a party to the transaction, they must disclose in writing that they are a licensee, okay, and that they have an ownership interest. And the disclosure must now be made to the purchaser upon having substantive discussion about specific real estate property. Now, the disclosure is in our sales contract, but this law requires you to do it up front. So if I'm listing a property and I get a call on that property, I'm making sure that everybody understands in writing, okay? Even if it's an email, at least in writing, that I am disclosing to you right up front that the seller is my husband, or the seller is my brother, or whatever your relationship is. I would disclose it right up front in addition to what's in our sales contract. So let me bring that sales contract back up again. So we still have paragraph 30 in our contract. Parties acknowledge that is an agent, active or inactive, and is the buyer or seller or is related to one of the parties in this transaction. So if I was going to put the other side on notice right up front, I would probably just incorporate the language that's in paragraph 30 and send them an email. Okay. Now, it's not enough just to tell someone, okay? Not enough just to tell someone that you are an agent. So there was another case here that I pulled up where everybody swore they told these people, but they were charged with improper delivery of documents, and the agent ended up having to pay $1,000 plus take classes at DPOR. So it's really imperative that you do this. Now, I'm going to just give you some common sense information here. When you talk to another agent or you have a conversation with your buyer or seller on the telephone, you need to have some kind of written record. Keep detailed records, or better yet, just send a text. If this is a pretty important thing, send a text to your party you talk to and say, this is my understanding of the conversation that we just had. Spell it out. And if you do not agree, then get back to me. Now you at least have a record, okay? A record that you discussed this, especially when it comes to transactions where the buyer said, I'm going to have a home inspection. There's another case here about that, but have a home inspection and they decide not to, then you need to go back to send something to that party, okay? That, hey, this is a material change to your contract. You're acknowledging that you're not doing this. Or if in this particular case that I have here, it called for the seller, who was also an agent and the party selling the property, to do a termite inspection. And the contract also called for a home inspection. Neither was done, and then the property settled, and then the party brought a charge. And the buyer and the seller, who is the agent, said, well, they said when they wrote the contract, it wasn't contingent upon this, but it was checked in the contract that it was. And the fact that these things were not done, the other party should have been put on notice. This is a what? This is a material change to the contract. Is this what you intended? Protect yourself. Okay? Because there's case after case after case for that. Now, another one that I want to discuss is the
Larry,
commission.
can I ask you
Yeah.
a question?
Sure.
And you are saying in the listing that I am related to the seller, and also when they're putting an offer, still you're writing them there. Do you have to again to send them an email and I said I am related to this person?
I would, because
I see.
our statute says, first of all, they may not, the buyer may never even seen the listing in the system. And by the time you get to the next to the last, what paragraph is this? 30 out of 33, they may have already jeopardized their position and offered you way too much information. So by putting them on notice up front, hey, I am representing this, I am related to the seller. I am the listing agent or the buyer's agent. And I need you to acknowledge that you're unrepresented in this transaction, or even if they are, they need to know. But, as much disclosure as you can make. And, we look at the statutes. So the statute's a little different than our
Thank
DPOR
you.
regs. So I think
Thank
DPOR reg wise, you were probably okay with this disclosure here in this paragraph, but statute wise, I would disclose right up front. Okay, right up
Hi,
front.
Larry.
Yes,
Larry, I have a question. So the paragraph 30 is only for the agent is related to someone, to the transaction.
if they're related to, or they are the actual buyer or seller.
Okay, so like if I'm not related to, or I'm not the buyer or seller, I'm just the agent represented to the buyer. So I don't
Then you
have
would-
to check anything.
No, then I would just put NA, not applicable. Because I don't leave blanks, and I don't want somebody coming back later and saying, oh, but they were related. Well, you find out later. And our law says if you knew or should have known, okay? Whereas this says, so if this is not needed, any paragraph that's not needed, put not applicable in it.
Okay,
Don't leave blanks in your contract, okay?
got
'Cause
it.
that just
Okay,
leaves it too open. And that
I
way,
see.
everybody knows, with NA, everybody knows, hey, you didn't just skip over that paragraph. You actually what?
I see. Okay,
Addressed it. Okay?
thank you. One more thing, Larry.
Uh-huh.
For the escrow agent or the RTS, let's say, if I'm the buyer agent, so I select the RTS, and the seller has prefer another settlement company. So in the past, so we can actually put RTS there, and
Yes.
if later on that the seller really wants us to go with the seller settlement, then we can actually change it later on. So what
You-
happened with changing now,
You-
with the new?
you- You could change it, okay? But so what we usually see in the listing is seller prefers that you use ABC Title Company, right?
Mhm.
And that means to you what? What does that mean if you're writing a contract for a buyer?
Normally, I don't really care. I just put, RTS. But then later on, they said, oh, if you go with us, then probably it's better for your contract. You will get the offer or something like that.
Okay, so I do not ever want anybody with Fairfax Realty saying that. Okay? All right, because if you pretty much tell me that I have to use that title company, and that's what the message is generally when we see it. They know they can't under paragraph 3 say what? Or paragraph 4, I'm sorry. They can't say you must, all right, because it says right in the law, okay?
Mhm.
It says that the seller may not, right here, require the use of a particular settlement agent as a condition of the sale of the property. Now, if you
Mhm.
already know there's 3, okay? If you already knows there's 3 contracts and it said the seller prefers that you use ABC Title Company,
Mhm.
okay? Then what is, in likelihood, what are you going to put in this blank if there's already 3 offers and they prefer their title company?
You
Probably
would
the one they
use
prefer,
them.
because otherwise they'll
Yeah.
probably just kick your contract out,
Right.
okay? Well,
Mhm.
make sure that you go over this with the purchaser, that, you know, the law says they have the right to choose, okay? And here's the deal. If the seller turns down a contract simply because they did not put their title company, because they can't what? They can't require it.
Mhm.
So make sure that you don't give the impression that if you don't put our title company in here, your party's not going to even be considered for this property, because you might find out that the penalty for that, if they were found guilty of requiring the buyer to use their agent, is 2.5 times the title insurance. So be careful how you word it, okay? And if the contract is, one of their contracts is the one that's rejected because they put RTS here instead of the other, don't say it was turned down for that. Just, you know, the seller decided on another contract,
Okay. I see.
okay? Be very
So,
careful with that.
so meaning that this, in this case, with the new changes, so the buyer has a settlement agent. The
Mhm.
seller, they can still stick with their own, their settlement. Is that correct? Or still have a spread
No,
settlement?
no, they cannot have a settlement agent or a title company. They must have an attorney,
Oh,
okay? And
okay.
it says right here, okay, there is only one what? One
Settlement.
sole agent responsible for conducting the settlement. So they would have to actually hire an attorney, not a title company. So don't put that the seller will be represented by ABC Title Company, okay? They have to be represented by an attorney. And
Attorney.
the misconception is that the title company is an attorney. They are not doing anything in this transaction. You understand?
Mhm.
Even though attorneys own the title company, the settlement agent, all they're doing is administrative and clerical functions. They are not giving any legal advice. They do not provide any legal advice. So they're not the attorney of the buyer. They are the attorney, they are the title company representing the settlement, okay? And if your buyer put in here ABC Title Company, right?
Mhm.
They have a legal question, the title company is not going to answer the legal question. Okay? They're going to have to hire an attorney. Now, the party doing the settlement may not even be an attorney, right?
Mhm. Yes.
Although the attorneys for the title companies, you know, drafted all the paperwork. All right.
Oh, I
So,
see.
you know, make sure they understand RESA, and you don't want to get involved in a violation of RESA.
Okay.
Okay.
So as a buyer agent, right? We select the RTS, the buyer agree, or select the RTS. So we
Uh-huh.
don't have to, as a buyer agent, on the buyer side, we don't have to worry about what the seller do, right?
No,
If they
no,
select the-
no. But if the seller wants representation, they can hire an attorney. And you know
Mhm.
what the new statute says is that this title company, and that's the problem between the title company and the attorney now. they can't charge. So this title company can't charge any fees to the seller that to the seller that the seller's attorney doesn't agree to. Okay,
Oh, okay, I see.
so but there might still be fees from, to the seller from this title company if, it's one of these things they have to do as an administrative and clerical function. But,
Mhm.
it's going to have to be a realistic charge, because my attorney would probably if I have a seller has an attorney, object to it. Now, the key to this is only if the seller has selected to be represented by an attorney. If the seller hasn't put in that they're going to be represented by an attorney, then all the fees that the title company would normally charge, they still charge.
Okay, I see.
Okay,
Okay, all right then. Thank you.
all right.
Thank you.
Any other questions about any of that? Good questions. Well, one last thing I want to discuss, and it deals with commission. Okay. An agent in the state of Virginia cannot receive anything of value directly from a member of the public. The only person you can receive commission or anything of value from is your broker. I can't even accept it from another broker unless my broker gives that broker permission to pay me directly. You understand what I'm saying? Even if they want to give you a bonus under the table, they want to give you tickets to a play because you were such a good agent for them, you've got to make sure it goes through your broker. Now, in this particular case that I want to share, the buyer agreement stated that the total commission of 4%, 3% paid by the seller, 1% paid out of pocket by the purchaser. And the 1% by the purchaser would go directly to their agent, not to the company. Okay. And this was in the buyer broker agreement that was submitted to the team leader. And I don't know why the company didn't pick up on this, but it was found out later that this money went directly to the agent. Okay. And the broker informed DPOR of this illegal compensation. Okay. And once the agent found out he couldn't do it, because he just didn't know he couldn't do it, then he sent the money back through the company and everything. And they thought that would take care of it, but it didn't, because he'd already violated DPOR. So that in that particular instance, they had to pay $500 fine. They had to complete 3 hours of real estate agency CE and 6 hours of real estate law and regulations within 6 months. And when you have this requirement by DPOR, it doesn't count towards your continuing ed. Okay. And it's pretty hard to find when they set these penalties up. One thing I found, it's pretty hard to find a class that's going to cover all 3 hours of real estate agency. Our continuing ed doesn't. So they're going to force you in to multiple classes to get this requirement done. I've never seen one of these things yet where you can go out and find a class, one class that will cover all the hours. Okay. And since these classes are blocked, like we do at NVAR, in order to get to 3 hours of agency, or just the hour of agency, you might have to take an 8-hour class. Okay. So it's, we have these rules and regulations. Think about what you're doing, stay out of trouble. Okay. So I'm going to open it up now to any questions anybody else might have about anything else you want to discuss here today.
Yes, Larry.
Okay.
Larry, can you touch on the post-settlement occupancy agreement?
What do you want to know about it?
Basically, recently I'm running into the situation a buyer want the house is as is a condition, which is the seller, the listing agent, it says that this is priced as is a condition. So basically, I'm assuming it's as is a condition home, the seller not gonna repair or replace for anything, I'm thinking. And then my client liked the house a lot. So we are going to write the offer on this home as is a condition. Now the seller also wants to rent month and a half in the house. So stay in the house for a month and a half after the settlement. So
Mhm.
we have to use that post-settlement occupancy agreement. So I
Okay.
wasn't sure if it's a good idea. See, it's as is a condition at the same time it's a post-occupancy.
Okay, so it's two different things. So your as is condition, okay, as of what date?
As is
So,
a condition,
so when you look at paragraph 10 over, well, it's not even paragraph 10, I think it's 9 now. So, but let me see if I can pull up the sales contract. Okay. Okay, so we have, actually, this is the old contract, but it's still the same. Be paragraph 8 now. So here's what I'm talking about here. Make it larger
okay.
for you. So what condition are they taking it? So as is, as of the date of offer?
Date of a home inspection.
Well, if it's going to be home inspection, they're not going to allow you to do a home inspection if they want an as-is contract. If so, you would not use the home inspection contingency addendum. You would use this paragraph that the seller will allow your buyer, okay, to bring home inspectors in, but for informational purposes only. Okay, so they wouldn't be able to back out of the contract, because when they're telling you as is, they're not planning on doing anything. So it's probably going to have to be as is as of the date of offer, which means whatever condition that property's in now is the condition it will be in later. Now, so when you're doing an as is, contingencies and clauses, I wish in here, under contingencies and clauses of the contract, there is an as is paragraph. So, and I want to make sure you go over that with your client as to exactly what they're agreeing to when they say as is. Okay. It's in this package somewhere. Bear with me. I'll find it.
Okay.
It's a good question. Okay. So this is your as is. I mean, this is your contingencies and clauses addendum form. And you will see here as is property. So exactly what are they requiring? Because our paragraph 10 says, except as otherwise stated in the contract, it's an as is. So are you agreeing here to pull out free and clear trash and debris? Okay. Buyer assumes responsibility for the smoke detectors. They are responsible for any damage for termites and wood destroying insects, any violations to the zoning code or health they're responsible for. And if it's in a POA and condo, are they going to take over the responsibility for all that? So you need to clarify exactly what they're meaning when they say as is. Okay. So if I'm the listing agent and it's as is, you're pulling all this stuff out of your contract. Does your purchaser feel comfortable doing that? Okay. Now, so
Larry, can I ask you a question? I
wait a
love
minute,
the contract because
let me
of
finish.
this.
Let me finish this and then
Okay.
I'll listen. So when you do this, okay, will there be a walkthrough? So there would be two, two walkthroughs with a post occupancy. One for the settlement, as is, but now for the post occupancy, you have to have another walkthrough between, not you, between the buyer and the seller to determine what condition your property is when the seller took it over. Okay, if they don't have that, then it's gonna be hard to prove that if the seller did any damage during the post occupancy, that they would be responsible, because they'll just claim, hey, it was that way when we did our what? When you did your walkthrough. Now, also under our post occupancy agreement, they added a paragraph, and this is important. Buyer and seller, you understand, this agreement is between the two of you. Do not call me the listing agent. Do not call me the buyer's agent to handle any problem that you have with this transaction that is not part of the purchase. It's not part of what you hired me to do, to be the property manager. So make sure, I think it's paragraph 5 in the post occupancy agreement.
Yes.
Make sure you go over this with the purchaser, because they probably don't understand any of this. But their only thing they understand is, we want this property, we'll do whatever they say to get it, until something goes wrong later on, and then they want to come back and sue everybody. So please make sure you go over these two that and the post occupancy. Hey, this is between you guys, and you need to do a separate walkthrough from the one that's part of this what? Sales transaction. Okay. Go ahead, Simi, you had a question?
So Larry,
I have, sorry.
Larry, follow that, as is property condition. So basically, as is, meaning you don't, as a buyer, don't get the home inspection, or the home inspection for the information only.
Well, it doesn't mean you don't, but more than likely, the owner doesn't want to deal with any of that, so they may turn the contract down or counter it back and take that out.
Okay.
And so the reason I'm saying use this paragraph, exactly what do they mean by as is?
Okay.
Okay, what do they mean? So, I mean, we're guessing.
So this paragraph is used by the buyer agent or the buyer?
Well, I mean, if you don't want any misunderstanding, so go over with the buyer and say, look, is this what you really mean when you say as is? Because it says here what? As is. Is this what you really meant? You want to take on all this liability just to get the property? So the best way to do it is go over it with the buyer and say, okay, so there's no misunderstanding. You know, you're pulling this clause out, this clause, this clause, this one, and this one, and you initial here. Now you're buying an as-is property.
Larry, I had a problem with this paragraph. I lost a contract offer because the listing agent want me to put a as is. And when you put in a as is, you have to check all of these, or one of them or two of them. The problem was the house was didn't have a trash. It was okay. But the listing agent want us to initial and also check each of them.
Yeah, I would too. That's as is.
But the problem is, if you look at them, it's not all of them as a building.
What did your buyer think as is meant?
As is, if it's whatever it was in the house, but she didn't want a home inspection. She didn't want a appraisal as is condition. But what
did the buyer think that as is condition meant?
Means that if it's need a paint, if it's need this, termite is okay. But the problem is, what it was saying that all HOA things, all of those, the program, they have each of them, they have something going on with them. So,
then your buyer didn't really mean they take the property as is, because this is what the seller thought it meant. The seller thought it meant all this stuff. Your buyer didn't think it meant all that stuff. So now that's how we end up in what? Court after the settlement being sued. So
But the
this
tax,
this-
the HOA is a part of the seller's,
not if they say as is.
that's what I'm saying. Yes, okay.
Yeah. So, you know, as a seller, when I said as is, I meant all this stuff. As a buyer, you thought it meant didn't have to be painted or if it
You
needs
don't
some
sign it.
termite work. So we gotta have a complete meeting of the minds or we don't have a contract.
Yes, I didn't recommend, that's why we didn't put the offer. Thank you.
Okay, okay.
Then, Larry, I did not see the listing agent listed these things on the listing website, the
Well,
document.
they didn't. So they said as is. What does as is mean? So what does your buyer think as is mean? What do you think the listing agent thought as is meant? How would you know? We don't.
Larry,
So we
Larry-
have to,
Document has
determine-
these
you can't
descriptions.
be a mind reader. So we need to make sure what? That we understand.
Okay, yeah, that makes sense. Okay, Larry, so let me ask you this. So as a buyer agent, if we don't see listing agent have this form attached to the document section, so we have to pull this form and discuss with the buyer, is that correct?
Yes.
As a buyer agent, we have to take this section and
Yeah.
talk to the buyer.
Yeah, say, is this what you thought as is meant? Because this is
Okay.
probably what the seller thinks as is means.
Okay,
And if it's not, then you shouldn't buy this property.
oh,
Because they're gonna come back later and even if you win the lawsuit, you have to get somebody to what? To represent you in a lawsuit. So why not just address the issue right up front?
Wow.
We have this paragraph to clarify what as is means.
Which document is this, Larry?
This is called the unrepresented, this is called contingencies and clauses addendum for NVAR. And it's form K 1344.
I have never seen it.
Well, it's been around for quite a while, since last revised in July of 2017.
so the answer is a condition, it's not a really, not
But what does it mean? You know,
a good thing,
okay?
yeah.
And remember, when you write something in a contract that says they're taking the property in as is condition, then the last paragraph in our sales contract now, okay? And I think it's the last, well, one of the last ones. Let me bring it up here again. The language hasn't changed, so any one of them will do. Let me get it up here.
Lots of buyer, when they say as is, that means they don't need the paint, they don't need to change the carpet or,
Did you ask them what they thought as is meant, or did you make that up?
no, they think it that way. It's
No,
not that.
no, listen to me. How do you know what they think?
I talk to them,
Okay, so
but when it
now,
comes to not
so
to
do-
paying the
so-
taxes,
so we just discussed, anything that's verbal means absolutely what? Nothing.
first of all,
Did you have it in writing? And that's what that addendum form does for you. Or use the adverse consequences to the real estate transaction form that says, we discussed this and we're not going to what? This is what it means. I get called in on so many problems in so many cases where everybody thought everybody understood because he said or she said. And the judge doesn't care what anybody said. They want to see it in what?
driving.
In writing. So here in this paragraph 31, okay, paragraph 31. Typewritten or handwritten provisions included in the contract will control all pre-printed provisions in the conflict. So when you write into a contract that they're taking the property as is, what did that mean? Well, that means any provision in your contract in conflict with what you wrote is now no longer in the contract. Is that what your buyer intended? Probably not. So you would use the what? Contingencies and clauses to clarify exactly what everybody meant. And then we don't go to court, or we don't go to DPOR, or we don't go to an ethics hearing. And you would check contingencies and clauses and clarify. Okay? That's all I'm saying. You know, you don't want to undo other paragraphs by just writing something in. That's the reason. Remember, there used to be right here a number 34 that said other. And agents used to write all kinds of stuff in under other. So now if you're going to make the contract as is, you're going to actually have to add another addendum called other and spell out what it is. Okay. All right. Good
Larry?
question. And I like the questions asked before we have a problem. So
I
good
use
job.
Yeah, what-
as is.
I put
Yes,
it in
sir.
the chat. I put in the chat the question, Larry.
I haven't been following chat, but let me check and see.
What are the major items that the seller has to disclose under the law to the buyer and as is listing?
Nothing,
Nothing.
except if they use the house as a meth lab, then there's a one-page disclosure. Okay. If there's a septic system waiver, there's a one-page disclosure. Okay. If there's a violation, a written violation of the safety building code or zoning, they received a written notice, they have to disclose. Okay, so you have some mandatory disclosures, and maybe that's what I'll do next week. But if you go to DPOR site under Property Disclosure Act, they have all of those forms. But remember, under paragraph 20, okay, it says seller will pay any special assessments, will comply with all orders or notices violations of any county or local authority, condo unit owners association, homeowners, POA. So these are things that have to be disclosed, or any action in court. So now there's a mandatory disclosure of a list pendants. But if you wrote, you're taking my property as is, my argument would be, hey, you removed all this stuff because any handwritten or typewritten added to the contract overrides all this other. That's why you go to that contingency. Did they mean to pull this out? Did they mean to pull that out? Did they mean to pull POA and Condo Act? You know, the buyer probably didn't, but they probably agreed to it by they're taking the property how? As is. Okay, because paragraph 9 says, okay, this is an as-is contract except as otherwise specified herein. And all the things on that contingencies and clauses addendum form that they can pull out are the otherwise specified herein that they've agreed to pull out when they said what? As is. Okay. So be very careful how you write in there as is. Do it properly.
Larry, I have another question, not related
Okay.
to this subject.
Okay.
So I have a buyer that wants to buy in Virginia Beach, and I want to make sure that I can actually show properties in Virginia Beach.
Okay, well, you would have to, each property, you would have to get something in writing from that broker that they will agree to pay compensation and that you can show the property, because we're not members of the,
Their
I don't-
association.
I don't think we're a member of that association down there. You'd have to double check with your manager. So
Okay.
what our code of ethics says, you're not entitled to any compensation that wasn't offered to you. And since you're not a member of that association, it was not offered to you. Now,
Right.
if it's also listed in Bright, then that's fine. But remember, it's got to be broker to broker that you can show it. Don't just take the agent's word for it. So have your manager send
Okay.
something, to them, especially if you find one before you write an offer, that
Right,
they're
okay,
they're honoring whatever compensation was offered. Because you're
Okay.
probably going to find these properties on a third-party site that offers compensation to a buyer's agent, but that does not cover you unless your buyer is willing to actually pay you.
right, okay. Thank you, I got it. Thank you so much.
All right?
Larry,
Yes,
I have one more question. You have time for that?
okay.
Okay.
I always have
Um,
time to answer questions that keep us out of trouble.
I I have a question on this, what is it called? The post-settlement occupancy agreement, right?
Uh-huh.
So let's say I look at the property maintenance and the condition, paragraph 6. It says the seller will maintain and repair the property, including all the things. Yeah. So I was just wondering, it says that it will maintain what after the
Okay,
settlement.
but maintain it from what condition was it in when they moved in? You can't rely on the what? Walkthrough from the contract. You've got to establish what condition the property was when they took over the post occupancy. So that they should be doing a separate walkthrough between buyer and seller to ascertain the condition of the property that they have to maintain. Because they can always say, hey, it was already this way when I took over. And you say, and your buyer saying, no, it wasn't. You did this afterwards. Well, show me where we have in writing what condition the property was in. And you're not supposed to be involved in it because we're not in the property management field in the contract. Once it's over, we're out of it. And that's why they put that disclaimer paragraph. You guys got to do this yourself. It's between you guys. And it even says in there somewhere, I believe, that you guys ascertain the condition of the property, not us. And a lot of people try to go back to the walkthrough that was for the contract, and it said it was for an entirely different purpose. Okay, because you probably checked in the especially if you checked in the contract that the property is in the condition, same condition it was as of what date? Let's say you chose date of offer. Well, that's a different condition, property condition, than what it is for, post occupancy. Entirely different condition. Okay. So document in writing.
It's interesting.
Don't forget, when they are removing the furniture, the carpet is going to be different when they're removing all the furniture out of the house. The house is going to be a little bit different.
Oh, including that pet stain that you didn't see because you did not remove it. And the property comes in the condition it was at that time, so you still get the stain. You say, well, they had it covered up with furniture. Then you should have wrote in the contract something about anything that you couldn't see is still what? Walk-through item. But hey, we don't do that, right? And then people say, what do we do about this now? The buyer wants the seller to give us a credit after. No, you don't get any credit. It was there. It said the condition the property was in at that time. Okay. Even if it's a home inspection, the home inspector's not moving furniture, right?
I see. So
I mean, there was a landmark case about this in Alexandria, down in the basement in the old home in Alexandria. They had this armoire that was so heavy nobody could move it, and the seller said this armoire stays with the place. It was here when I bought it, and I'm leaving it. I'm not trying to get it out of that basement. New owner didn't want it, so they had it dismantled. And behind the armoire was a big round hole in the wall that was used for people to escape. Okay, an actual tunnel. So, and they went back and said, well, the seller hid it. The seller said, I didn't hide it. It was there when I bought it. You should have moved it, checked it out yourself. And the court agreed. Okay, this is Virginia.
So this
Okay.
is occupancy seems very confusing. I guess it's not a good idea to do that.
No, they should. You know what I think? You ever seen the warning for poison? Like skull and bones with a cross through it. They should have that on top of that form. It's poisonous, kiss of death, We get more problems out of post and pre-occupancies than anything else in our industry.
Oh, I see. All right, thank
And
you.
that's why we made this to be between what two parties? Buyer and seller, and leave us out of it.
Hmm. Wow.
Okay?
Thank you, Larry.
Well, thank you guys for joining me and all the good questions.
Thank you.
Thank you so much.
Okay,
Thank
we'll
you, Larry.
see you guys next Monday. Thank you.
Thank you.
Thank you, Larry.
Okay.
Okay, bye. Have a good